There are four big questions that the court's going to grapple with. The first is whether the minimum coverage requirement, which is known as the mandate, is constitutional. The second is whether the Medicaid expansions are constitutional. The third is whether, in the event that the minimum coverage requirement is declared unconstitutional, the entire law falls at that point. And the fourth is a procedural question, and that is whether the Anti-Injunction Act, which is a special law of Congress, actually bars the court from hearing the case at all, at least that part of the case that involves the minimum coverage requirement. In order to think about the importance of this case, one would have to go back 70 years or longer to identify cases that were this important in terms of telling the American people what powers Congress has to grapple with a national health policy problem. The only way that the country is ever going to get control of its health care costs is to get all Americans insured and then to be able to start regulating the amount of health care and the price of health care and the consumption of health care. But in order to do that, you have to bring everybody into the system so that those people who are already basically hanging on for dear life, having a real struggle getting health care, are inside the health care system and are part of the solution. If we don't take this opportunity to insure everybody, then the efforts to try and control health care costs for the nation just fall apart because there are too many people outside the system. There are too many people known as free riders whose costs have to be borne by the system some way and get cost shifted onto the rest of us as well as onto government programs. The individual mandate is sort of at the same time both integral to certain parts of the law, but it also is simply part of a much bigger law. So on the parts of the law that we probably all care the most about, that we understand the best, namely the insurance reforms, bringing down the minimum coverage requirement means sacrificing the two core principles of this law, which is that nobody should be excluded from insurance because of health status, and that people who are sicker should not be charged unconscionable rates for their health insurance. Those are the heart of the matter. Those two provisions, according to the Justice Department, which is of course defending Congress and the administration, are the two provisions that cannot survive without the minimum coverage requirement. There are a lot of other provisions in the law that certainly could survive, which is why most people do not think that the Supreme Court would declare the entire law dead if the minimum coverage requirement goes down. If the minimum coverage requirement is struck down, but the law is deemed severable, then Congress faces two choices. One is to step in and rectify the minimum coverage requirement, that is, fill in the hole with perhaps a voluntary system where you are encouraged basically to get health insurance and penalized if you don't, but that would preserve sort of this core structure of creating an insurance pool. Or Congress could decide for policy and political reasons that with no minimum coverage requirement, it doesn't want to save any part of the law. It could repeal the law.